Thanks everybody for joining me again this Thursday, March 3rd, at the Rafi Law Firm webinar. Thursday mornings with Mike, let's call it. I don't know. Today, I'm not going to do a very big intro because I want to use as much of our time as we can with Alan Holcomb, who's going to join us here. Alan is a former defense lawyer. He did defense work far longer than I did. And he and I have become friends over the years. And I think he is probably the best resource that I know to talk about what it's like from the other side of the curtain. Alan now is handling cases all over the country and some really big cases. I'm sure he'll tell us about some of that. But I'm going to have him join us here. And what our plan is for this session is to go through things that I want to know, because I'm the one with the list to begin with, but things that I want to know and I think would be helpful for all of us. Some of these questions, truly, I don't know the answers, so I'm really excited to hear what he has to say. And for y'all to tell me anything you want us to cover, anything that sticks out in your mind. I think we spend a lot of time focusing on what we can do directly, what we control, and that makes a lot of sense. The point of this webinar is to go 1 degree, 1 iteration away from yourself and say, what can I do to affect someone else on the defense side? So that way they will or won't do something that will help me with the case. So Alan's going to join us right now, and we're going to get right into it. I haven't prepped him at all. Alan is like an unprepared deposition witness right now, who's just going to come in and answer questions and tell us things, and hopefully it goes well. That's the plan, right, Alan?
That's the plan.
All right, where are you at right now?
Morning. I'm in Phoenix, Arizona, in my hotel room. So I tried to clean up behind me. So apologize if anybody's offended.
It looks like a nice hotel room. I'm kind of jealous here. You have the peace and quiet, depending on who's been calling or bothering you. You have the peace and quiet, at least, of a hotel room in the morning, which a lot of us don't have. I've got a dog down on my feet, and I had screening people here today. So give us the quick background. My intro for you did not do you justice. I readily admit that. But tell us where you worked, how long you worked there, and just give us the quick overview.
Yeah, sure. Thanks. Well, first of all, thanks for having me on. I really appreciate it. Mike has become a good friend and really helped me as I transitioned from defense to plaintiff, and kind of taught me some of the tricks of the trade on this side. So I appreciate it, and hopefully I can add a little value today. So I was a partner at Weinberg, Wheeler, Hudgens, Gunn, and Dial. I was there for about 10 years, did both of my summer internships there. So a total of 11 years or so. I worked in a group there under Billy Gunn and Chuck Clay and some other folks that people might know, where we were taking kind of the worst cases across the country and jumping in late to either try to settle them for a favorable number or try them and try to minimize the damage. So I did that for about 10 years and then jumped over about 3 years ago and joined my partner, Brett Turnbull.
One of the reasons I thought you would be an awesome person to do this webinar is, although I have some defense experience, I worked at Troutman Sanders for a couple of years there, I didn't have any insurance clients. All my clients were self-insured, and that in a lot of ways was really good for a lot of reasons doing defense work. But since making the switch, however many years ago now, I didn't have that background of how insurance companies work and how they interact with their lawyers, because my self-insured clients did things very differently depending on how they wanted to do things. I know that AIG was one of your big clients. Who were the other ones that you typically work for?
Yeah, so AIG was a big one. Taurus Insurance, which has now been subsumed by other insurance companies. Ace, Chubb, Allied World was a big one. We tried a bunch of cases for them. Really, it was kind of a smattering of all of them. Weinberg Wheeler does mostly excess insurance defense. So it was kind of the big boys, so to speak, that we would work for.
So I was trying to think of the best way to go through this, and what I came up with, I got your list and I've got mine. What I came up with here in the last 5 minutes is this may be the easiest to go, or maybe the easiest to go through this with almost the life cycle of a case in chronological order. So let's talk about from the defense side. You get notice of a case, whether it's from initial filing or you get a letter rep or whatever the situation is. What is the first thing that happens on that side with the lawyer working with the insurance carrier?
So it's probably not all that different from when you're working for a direct hire, so a self-insured company. But if you get notice of the case pre-suit, it's usually a pretty bad case for the defense at that side, at that level. And so initially you'll start an investigation. Sometimes if you got a letter of rep from the plaintiff's lawyer, you'll reach out, try to get a little bit more information about the case. You hire investigators. And really the most important thing, and I think we'll get to this more in depth, but it depends on the insurance company, but certain insurance companies want you to begin a report on the case basically as soon as your investigation starts. Some of them want it 120 days into the case, but it just kind of depends on whether it's in suit already or pre-suit. So you'll have an initial call with the insurer, so with the adjuster and the client, and you kind of get the facts from them, and then you start gathering records such as the police report, any medical records they already have. And I'd like to say that a lot of times you come up with a plan together, but depending on the type of case, it may just be the defense lawyer setting the strategy for the initial investigation. The bigger the client, the bigger, if it's Coca-Cola or some other type of larger company that handles a lot of litigation, they'll have kind of their checklist for you to go through.
One of the things I'd noticed when you sent over kind of the list that you thought we'd talk about, I'm going to read this quote that you wrote: "Never going to do ESI search unless you initiate," which I am smiling so bright. There's somebody, Michael Arndt, on this webinar who knows why I'm smiling, because him and I have a similar case where some ESI was not searched, definitely destroyed, and so on. At that, and I'll make it a broader question than ESI, but at what point does meaningful, serious preservation of evidence begin from the client side? I'm not asking you. I'm saying from a client side. I'm not. Lawyers tell. I know you're telling your clients to do that, but what's your experience with that? I can't keep a straight face on this one.
When they get a motion to compel. Yeah. I mean, that is sad to say, and I'm not trying to dog on defense lawyers, because most of my best friends are defense lawyers. I love Weinberg Wheeler. I left all my best friends behind, but most defense firms are run by I'm trying to say this tactfully. They're run by people who grew up in an era where ESI probably didn't exist, and they never really teach the people below them what ESI is. And we all know that's really where you get the best evidence. I mean, nobody's writing out memos to send inter-office anymore. So yeah. First of all, the defense lawyers don't really understand what ESI is. I mean, to a certain extent, on the plaintiff side, you're having to do their job for them. Yeah.
Without the benefit of knowing the defendant's internal systems to tell them where to look or how they do it.
Right, and they don't even know. And so what I've started to do lately is, instead of sending and honestly, I go back and forth. Some cases I do it. I still kind of do it the old way, where I ask for all emails regarding XYZ, but I have not had a lot of luck the last couple of years actually getting meaningful productions doing that. So I almost start my discovery now with, tell me all the systems you use, tell me who the custodians are. That way they have to go learn from their client. Okay, did they use Outlook, Gmail, whatever the case may
be? Yeah. I've done 3 or 4 of those in the last 3 or 4 weeks. That's been our newish, where if we can, I've talked about it on these webinars, that you can go around the lawyers and just go directly to Steve in IT or whoever. You're going to get a better answer, because either Steve's going to be woefully underprepared, meaning he's going to just tell you the truth, or Steve's going to tell you things that don't make any sense, and either one works for us.
Yeah, so it's really interesting. I'm glad other people are kind of running into the same issue. But no, I have had no luck, and this is the reality of how written discovery works on the defense side. The plaintiff's lawyer sends over the discovery request. The defense lawyer usually will go through and take all the legal jargon out and make a bullet point list of what the client needs to go get, and they send them on to the in-house person at the company. If it's not a company that's quite that big, you may be dealing with the owner of the company, who certainly doesn't know a damn thing about ESI or text files, all this other stuff. They don't know. They have no clue. If it's a concrete company, you're not going to get a guy who knows that much. He knows a lot about concrete. He doesn't know a lot about computers. So the defense lawyer will send the list on. They'll get documents back or information back from the client. And in the defense lawyer's eyes, we've done our due diligence, right? We sent the letter on. They said it didn't exist. What are we supposed to do? And so we'll respond back to the plaintiff's lawyer. Either it doesn't exist, or
my clients told me, as far as I know, it doesn't exist is usually the answer, right?
Right. Yeah. Or they'll produce 7 emails that, Joe, the manager, he quickly typed in the property name, and those are like the last 7 emails that came up, and so they produce them. And we can get into it more in depth later, but I've started to use that as a weapon. I mean, it's a great way to get the court on your side. I'll just say that.
Yeah, I've talked about them here. I think I've shared our 30B6 notice, at least out there with some folks. And if you want it, anybody send me an email. It's helped us a lot. The most infuriating thing, though, there's one way to make me more mad than just not producing me anything, is we do the custodian deposition. We ask for what we want to ask for. And then the most important question, I think, is how easy is it to get whatever? How easy is it to get that? Oh, it takes 5 minutes. Oh, it takes 30 seconds. And then you send the request for that specific thing. We cite page numbers of the deposition transcript if we can. And we say, we want XYZ, see this page. It will take you 5 minutes. And then we get it that it's broad, overly burdensome. And I'm going, what? I made your job easier for you, defense lawyer and client, but everybody's just trying to cover their butt. Because I think, with respect to you and defense lawyer I think defense lawyers know that they usually don't have everything, and it's just about what if the lawyer's comfortable saying, that's what my client told me, or if the lawyer's going to push his or her client and say, hey, this doesn't make sense. There's got to be more. There's got to be more. And I don't know how often that happens. It's hard to tell. So you start your initial investigation and you write a report, let's say in the first couple of months, if not sooner. What are the key things that you include in that report?
Right. So most insurance companies have a form that they want you to use. Actually, every insurance company, for the most part, that I ever worked for, had a form that you want to use. And I actually had an old one that I looked at yesterday, kind of preparing for this. But, generally it's kind of a lot of the big stuff that as a plaintiff lawyer, you should really be thinking about at the beginning of the case as well. So stuff like venue, what are the injuries, who are the potential experts that you would need in this case, the basic facts of the case, who the plaintiff's lawyer is, who, does he or she have a track record of trying cases, and then, the most important in the adjuster's eyes to start the case is the budget. So usually, even though you, as a defense lawyer, have no clue the universe of witnesses that may or may not be out there, you're supposed to give a budget through trial in most cases. Now, I was able usually to say, listen, I have no clue if this is going to be a 2-week trial, 4-week trial, 1 week. Can we just do it through the end of discovery? Yeah. So those are the basic factors that you have to lay out for them as early as possible.
In your experience, are insurance companies typically over budgeting or under budgeting? You have a sense of that?
I would say over budgeting. Maybe that was just us, but Weinberg Wheeler did have kind of a higher rate than most insurance defense firms. So I always tried to put a lot of fluff in there because you don't know where it's going to go. I mean, it's not anything tricky, but you wanted to give yourself some leeway, because the worst thing that happens is the insurance company comes to you and says you blew through the budget, you're overbilling the case, and you're just doing your job.
Yeah. Is there anything, I don't want to assume, is there anything that a plaintiff's lawyer can do to put pressure on a defense budget right off the bat? So is that a pressure point with some carriers?
Absolutely. So depending on the type of case you have, right? So I'm in Phoenix, Arizona right now for a transvaginal mesh trial against Johnson & Johnson that starts Monday. The budget's not going to matter to them, really. I mean, they have so many of these, they've been doing it for 11 years, who cares? But if you have kind of the standard case that, our firm handles and everybody else handles, the budget matters a lot, especially to a primary insurance carrier. If it's a case that's in the low six figures, high five figures, the budget is going to drive a lot of whether you get paid early or not. I mean, most insurance companies now are ran by the bean counters. They're not run by old school insurance adjusters who want to protect the client and kind of jump in the trenches with the defense lawyer. So what I've started to do recently is actually almost lay out to them, this is what your budget should be. I don't give them the numbers, but I say, okay, we know that these 5 witnesses are out there. We suspect there's going to be another 5. We see that this is going to be a 20 deposition case and you're going to need experts. And we've started to send letters saying, set the reserves high.
Yeah. Now, when you say reserves in that context, you mean budgeting reserves, right?
Correct, not indemnity.
And I was going to ask, there's 2 buckets, right? There's the expenses, and then there's the actual, let's call it settlement money for easy numbers here. When's the best time in general for a plaintiff to start, if at all, talking about how much they think the case is worth? And I'll tell you, from my perspective, in some cases, for strategic reasons, I will purposely not address how much I think the case is worth at all, especially a case I put right into suit. I don't want to send off, tornado sirens. This is a big case. You guys are screwed. Give me your best shot. Other cases, though, whether it's because my case truly is that good, whether because I have pressure from a client to get the case settled quickly, whatever the reason is, other times I'm saying over and over, I call it, not to get political, I call it Donald Trump theory. If you say it enough times in a row, people will believe it. That's the one thing that we know from him and through other politicians. I keep saying, this is an example. This is $1 million case. Well, this is $1 million case. $1 million case, $1 million case, $1 million case. What are the considerations that should go into sharing with the other side how much you think the case is worth?
It's something I struggle with and go back and forth because, as you've identified, a major problem, especially with some defense firms, are they want to hold on to the case and bill it. And so even though we all know where this is heading, it's a good case, they're going to pay the case eventually. They'll under reserve it, or the insurance company will under reserve it. And the worst thing in the world is trying to get a really good case settled that's been under reserved, because there's a lot of ramifications for that from the adjuster side. So I have certain cases where I know it's a good case, and frankly, the insurance company doesn't, and they've hired a weak defense firm, and I want to take advantage of it.
Yeah.
I have one in mind right now, and I'm not going to identify it, but where I want to get the evidence in before the good lawyers from the excess carriers come in to clean it up. So, but I err on the side of telling them early on, this is a multi-million-dollar case. This is $1 million case, 500,000, whatever the case may be, because I don't want to be holding the bag. It's not my fault. I don't want it to be my fault 2 years from now when the case can't get paid because some, primary layer insurance defense lawyer said it was a defensible case when really it's a $3 million case. I mean, that's how nuclear verdicts come about.
So you said, and I think I know the answer. You're going to tell me about grading, but for adjusters on the insurance side, why is it a big deal for them to change a reserve after 2 years? You know, you get through discovery, I'm saying 2 years from this date of the crash or whatever it is, you get through discovery, everybody looks at the case and says, you know, shit, this is a $1 million case. The adjuster, maybe because the defense lawyer had a bad take on it, maybe because they didn't do their due diligence, whatever it is, told them at the beginning of the case, it's a $250,000 case. Why is it so hard for an insurance company to kind of reverse track and say, yeah, it's $1 million, here's your $1 million?
Okay, so there's kind of the micro and the macro. So on the micro side, especially after the 2008 financial meltdown, the insurance companies are run by, like I said, kind of the bean counters. So every adjuster now gets graded on how accurate their reserves were and whether they had to change it all. And why it's a big deal for them to have to change reserves, you got to understand what reserves are. They're essentially setting aside money that will be paid out through the claims process. And on the macro level, most insurance companies nowadays aren't insurance companies. I mean, insurance is one of the things they do, but I looked at them like investment banks. And you know, it's been 12 years since we had a recession. They want to be able to invest and use their money and make the 10% gains or 8% gains. So that is probably the most important. The reserve setting is probably the most important thing on the insurance side.
What if you want to sell, and truthfully so, that your case is worth a certain amount of money, other than repeating it over and over? What can you do? I mean, I'll tell you what I do. We kind of like what you're saying with expenses. I map out our whole case. I actually write the letter to the insurance carrier with a similar letter to the actual client, meaning the defendant, the actual client. And we kind of map out what we think, you know, obviously avoid key things that we can't prove or that we're still trying to develop, but we truly give them our best shot and say, here's what the case really is. The fear I have when I do that every single time is, one, they're going to know everything that I know now. Two, they're not going to give a crap. And then number three, I'm going to have made my life more difficult in a big picture. I've made my life more difficult by sharing everything I have. What do you think about that? Or how do you tell them this is a big case, this is whatever?
So I take a similar tack, and I'm like you. I err on oversharing because let's face it, most trials today are trial by video. So I think the days of holding something back for trial, you know, maybe in a rare occasion you do that, but obviously you don't want to tip them off before the deposition because you want to throw the document in front of the client, in front of the opponent. But yeah, so it's a struggle. But what I've started to do is I start reporting to the insurance carrier as if I'm their lawyer. I mean, the tone of the email isn't like I work for you, but if I have a really explosive deposition, so we have a negligent security case in Las Vegas right now, and I've settled with one defendant, and I'm not going to get into specifics because the case is going on, but we got another defendant who has a lot of liability in my view, and I don't think they're getting great reporting, the insurance carriers. So we'll have an explosive deposition, and I will give a bullet point summary of the deposition, almost like I'm reporting to an insurance carrier. And at the top, I put in all bold, please give this to your insurance carrier and, you know, XYZ company directly, and let them know this is what happened. Yeah,
we do that right out of depots. Actually, the most recent time I did it was after a sanctions hearing recently, about 2 or 3 weeks ago, where, you know, you send a letter immediately after, and this was to the client and the insurance company, the defendant. Dear you guys, this went really bad for you. You should know that. And actually, the judge ordered this company's corporate representative to come down from Michigan and be in federal court here in Atlanta. And I had sent a previous letter, and when the witness was on the stand, because I'm looking for there's other things going on in the case, I said to the 30B6 witness, "Do you ever get this letter I sent you after so-and-so's deposition?" "Nope, I've never seen that before." "Your lawyers didn't give you this letter?" And it puts the lawyers in a bind too, and they might want to hopefully, you know, circle back and give the letter and also get out of the case. I mean, that's my hope. You mentioned bad reporting. And that is let me define this for anybody who doesn't know, at least. By bad reporting, you mean a defense lawyer reporting to the insurance carrier what is or is not going on with the case and what are the risks and rewards of not settling or settling. Fair description?
Yes.
I assume that there's bad reporting in every single case, other than trying to go around the defense lawyer by writing directly to the insurance carrier, or to the defense lawyer or the insurance carrier through the defense lawyer. Any other ways that you can prevent bad reporting, prevent a lawyer from not saying how shitty the case is going or how terrible of a job they're doing? I mean, it's hard to do that. It's hard to tell the insurance company, hey, the handpicked lawyer you guys hired, this dude sucks. This is just, I wrote in a letter recently, I think I told them that this case was like a dumpster fire. Well, it was something in a dumpster on fire with a nuclear bomb about to be dropped on. I thought that would get somebody's attention. I don't know if it did yet. I'll find out later. But what are some ways you can do that to avoid that or prevent that?
Get the deposition of the decision maker. I have some cases where there's a parent company involved, and there's some certain states' laws you can allege joint venture. You may not need to, but we know that that parent company is the one who's actually making the decisions. And so the further up the chain you can get to the people who are actually the ones that insurance carriers care about, the better. And so, and then, so that's one thing. And then the other thing I think is just the way you handle depositions. My view is that depositions aren't for discovery. Written discovery is for discovery, and depositions, your job as a plaintiff's lawyer is to make it as bloody as possible.
It's interesting.
That way they cannot get around reporting that it was bad. I mean, that just make it as inflammatory and within the rules and professional and ethics and all that, but make it as bloody as possible so they cannot justify saying, well, the depo went okay.
That's interesting. I've never thought about that justification, because I struggle a lot of times. I guess I have thought about it, but I struggle more so. Do I want to impeach this person? If I already have it, do I want to do it in a depo? You know, am I wasting it if I know this person is going to be live, or I'm going to have another video dep later? That's an interesting point, because you send the transcript along. Let me ask this. Do transcripts get sent along to insurance carriers, and do you think they read them?
No and no. No, they have too many files, and they're, everybody's passing along the responsibility, right? The defense lawyer is saying, well, the client didn't give me the documents they should have, or it's just a bad case. And then the insurance adjuster, is saying, well, I was relying upon the reporting of insurance defense counsel. And so no, they're not gonna, unless you're at the very end and it's a very high value case, the insurance adjuster is not going to take the time to read the transcript. And frankly, most insurance adjusters are failed lawyers. And so I don't trust them enough to actually read the transcript to know whether it's good or bad anyway.
You mentioned decision makers, and I want to touch on that topic from a different point of view, a different perspective. I'll start this, I guess. Who is the decision maker in a case for whether it gets settled? How do you figure that out?
That's a great question, and it's different with every case.
That's such a lawyer answer, by the way. That is such a lawyer.
I know.
I know that's true, but tell me who the options are.
Right. Okay. Well, I think we can break it down by type of case. So if you have a rear ender car accident, the adjuster you're going to get has a certain amount of what they call table authority, and it may be 50,000, 150,000, 250,000, whatever the case may be. And so they are the actual ultimate decision maker in those cases. That's the person that you need to be trying to convince. If it's a if it's a bigger, quote unquote, bigger case where you're dealing with higher damages and you're dealing with a big company, it's generally going to be the in-house person who you need to get to. in every case that's, let's say, over $500,000 million, what I'm trying to do is get to the in-house person for them to write a letter to the insurance company saying, pay the case. And if you have a very high value, or high damages case, that's why it's so important to get all of the insurance information as soon as possible, because the decision maker may not even know about the case.
All right, so tell me what's a situation where that can happen, and why does getting all the insurance matter? I mean, even if you think your case is worth $1 million and the first layer's $2 million, why might you want to know that larger layer that maybe has the coverage of a $5 million excess policy?
So the best position you can be in as the plaintiff's lawyer is having the insured writing a letter saying, settle this case, I don't want excess exposure. Well, the next best is having the excess carrier writing down to the primary layer saying, you're exposing me by not settling this case. And so, it may be a scenario where you're writing the letter actually to the excess carrier saying, this is how bad the case has been. They have the opportunity right now to settle it within their primary layer. They're exposing you to risk, and you need to put pressure on them to settle the case. So, and if you don't know who the carriers are, you can't do that. And most of them are sophisticated enough. Most of the insurance companies are sophisticated enough to where they put everybody on notice that they should. But you run into scenarios sometimes where they've never contacted or even tried to figure out who the policy is above.
I've been in that situation before, or they tell you there is no policy, and then you find out. I tried a case. This was a while ago. I tried a case, I think in 13 or 14, where after the verdict, got what we thought was an excess verdict, then found out there was more insurance. That verdict got paid in full with to the penny, without any appeal, no discount, and nothing else was made of it. But I actually heard Cash Kruger years ago had a case where there was no where a decent amount of insurance was not disclosed, and unfortunately, that Georgia statute just has no teeth to it, no bite. If they don't give it to you at all, let alone if they give you bad information.
Right.
In terms of the initial investigation that the defense lawyer is doing, is there typically witness work going on? Are they going out and are you instructed as a defense lawyer? As a plaintiff's lawyer, I'm running out trying to interview everybody I possibly can in the world. What from my experience was, especially with one of my clients, Georgia Power, that was not something that they were willing to pay for or have you do. If there was I had one case, I remember a generator exploded and hurt this guy pretty badly, and there was 10 people all around. So they had some witness statements. I forget how they had them, but there were other people that no one had talked to. My first reaction is we need to go talk to all these people, and the answer was no. That's not something we're interested in. What do you see about the depth of the investigation before really the case is rolling in discovery?
So you're right, and that's been my experience as well. Is usually they're not going to pay for you to go spend a week, going to apartment complexes and talking to the managers or doing whatever the case may be. So that is a major advantage that we have on the plaintiff side, and frankly, it took me a little while to get used to and to really, I think, weaponize is that we have access to the most important people in the case well before the defense lawyer ever talks to them.
Yeah, and it's also a reason why not to immediately run and file suit, because as soon as you file suit, then the defense lawyer has the authority, the budget to go do all that. In some cases, we wait 2-3 months if that's what it takes, so that we can get everything ducks in a row, and then we're at such a huge advantage because you already have all the information. We had one case.
The case is over. The case is over.
We had one case, and it's still going on, but we had one case where we got an affidavit from a security guard in an apartment complex, and we sent that to the defense, to the insurance carrier pre-suit, and all through discovery, they still maintained that this guy didn't even work there. And here I am with an affidavit from them that I shared with them, but I knew more about their apartment complex than they did. I mean, and that's just the way that it can always go, because we have access and they don't, or they're not willing to grant themselves access, I guess.
Right. And in the reality, if we're just being honest about it, most defense firms, most defense lawyers have too many cases, and so even if they're given the authority, they're not going to do it.
Well, let's talk about defense lawyers. in general, of course. What, other than billing, what I found at least is that the best defense lawyers have the most work and have the best clients, and they don't need to churn out another however many hours on your case because they got enough work to do. But I certainly have had the experience that a case won't settle, and it seems like it's because I have to go through these motions that I shouldn't have to go through. And when I mean motions, I don't mean written motions, although that might be included. I mean, go through the motions, the process, just to get to where we all know it's going to get. I have a case like this right now, where I wrote on a piece of paper and slid it over to the defense lawyer when I saw him in person. I said, this is how much this case is going to settle for one day. And he's like, yeah, I agree. Okay. But what are the goals of a defense lawyer? And that sounds very broad, but I know it's to do good work. I know it's to make money, but what about keeping clients happy, and how do they do that to get more business?
Right. So there's a couple aspects to it, and I'm not trying to give lawyer answers. It's different for every type of lawyer. So one thing that I've run into a lot more on this side are kind of older defense lawyers who have a single client who that's all the work they do is for that single client. The goal of that defense lawyer is to keep that client. So I've found that they are much less likely to take a case to trial and to really get themselves in hot water with the client. And you can use that to your advantage. But yeah, the other goal,
you need to give those folks an out to look good to their client. They need to settle the case, give you what you want, but also look good in the process.
Yeah, I call it the golden bridge. You
Okay.
need to find that, you need to build them a golden bridge where they can walk over to settlement, where it makes them look like they beat you up good enough, their client's happy, but where you're like, well, I would have taken way less than this. This is so that's one motivation. And then really how they're judged is not by results. I mean, I have gotten defense verdicts as a defense lawyer in cases I had no business getting a defense verdict in. And you would think that the floodgates just open and they send tons of work. The outcome of the case almost doesn't matter. So for how insurance defense lawyers keep their clients happy these days is not billing as much as they probably should, and settling the case within reserves, and doing it quickly, right? Because adjusters are also graded on how long a claim has been open. So it's they're contrary to the defense lawyers' goals, which usually are to delay the case and keep it going as long as you can. So yeah, it's under budget for costs and expenses, within reserves, and as quickly as possible.
Yeah. I was reading through the notes that you and I shared with each other, and one of the things that we both talked about was that defense lawyers can be your friend in a case. They can work for you. Walk me through, if you can, and for everybody here, a situation of how you would make a defense lawyer be an asset, because my general tact on cases is either I'm going to destroy your world and make your life miserable, not by doing anything wrong, but I'm going to work this case. And you're going to have to spend an ungodly amount of time on this one case when you have all these others. So, hey, maybe you want to think about getting rid of me. Or in other situations, I'm going to say to the defense lawyer, what can I do to solve your problems? What challenges are you facing? What issues remain unresolved? You and I have a mutual friend at a firm you used to work for. Say, I know he's the person I can say to him, what are the issues you're getting pushback on? I can go and solve them for you, and I'll get out of your way. Tell me about your experience on both sides with that idea.
Yeah, and honestly, I don't know that I can say it any better than how you just said it, but that's exactly right. One of my favorite movies is Michael Clayton. It's probably my favorite lawyer movie.
Is that George Clooney? Is that my thinking back right? Okay.
Yeah,
that's a weird favorite movie. I'm gonna be honest with you.
Well, maybe it's because I felt like I was living that movie for a little while, but he has a line at the end of the movie that's something to the effect of like, I'm the lawyer that you pay off, not the one you try to kill. And so you figure out early on, figuratively speaking, obviously, whether this is a lawyer you got to make friends with or one that's going to have to die in a figurative sense. So it's tough to figure out who that person is, if they're a true believer or not, or whether they're essentially, going through the motions, or if they're true trial lawyers. I mean, there are some still defense lawyers out there who are true trial lawyers. They're not going to try to hide from you, and they're going to get you the amount of money they can. And if they can't get that, if it doesn't do it, they're happy to try the case. There's not a ton of them, but they do exist.
Those are the guys I don't want to, guys and girls, that men and women, I got to make sure I use the right words here. I'm trying to, at least. Those are the people I don't want to have cases with. And I think the way you can tell if somebody's a true trial lawyer is they give you everything in discovery, don't make bullshit objections, and just say, here's what you got, here's what it is, what do you want to do? And here's the money. Here are your options. And those are the people, I got one of those right now, one of my best cases. I to my detriment, I guess, to a degree, I outworked the first lawyer that the insurance company went ahead and replaced him with somebody else. Same insurance carrier replaced him with somebody else who most people on here know. And he goes, I'm going to give you everything. He sent me discovery before I even asked for it. He sent me documents. I'm like, I already knew this, but I'm like, shit, this is not how I want this case to go. I don't want to be put in that decision where, here's what I got, take it or leave it. It's the amount of money, the best I'm going to get for you. You make a decision what you want to do. I don't want to make those decisions. I want to make easy decisions. Offer me little and let me go try good cases. Offer me a lot and let me settle the cases for above value. That's what I want.
Yeah, those are the scariest defense lawyers for sure, because they're not going to help you. I mean, there are a lot of insurance defense lawyers who are going to drive the value of your case up at trial by focusing on dumb things, by just taking too long with the jury, by blaming your client. And the guys and girls out there who just take the case as it is and don't try to hide anything. Those are the ones that worry me as well. But they're hard. So the question, so early on, you got to determine who that is, what type of defense lawyer you're dealing with. And if you're dealing with the latter, who's basically, he or she's just trying to hold on to the client, is help build that golden bridge. So set up a scenario. Sometimes I'll call them and I'll say, listen, I think this is a high value case. You and I may disagree. That's fine. But I don't want to be stuck in a scenario where the reserves aren't set correctly. So, and if you settle the case within the reserves, you're going to look good. So what can I give to you that will help get the reserves high enough? And then we'll just fight about it. We'll figure it out. And then if they come in at the end and pay you a number you're comfortable with, they look like they're the king.
Yeah. You've mentioned trial a couple times, and I'm going to get there. But one thing you just said that I want to touch back on is I think you called it the admitting but defense. We admit we're responsible, but which I worked for a really good partner at Troutman who now is a plaintiff's lawyer. And I remember in a case, in an answer, a draft, a very early draft answer, I denied everything. He pulls me aside and says, no. That is how you get, what the phrase you use, that's how you get a nuclear verdict. That's how you get hit and make people angry. And that always stuck with me. And my clients on that side were very aggressive in admitting things. There's always the but, though. Who's the decision maker in that choice about what gets admitted and what doesn't?
It's still the insurance carrier for the most part. I mean, you can have the sometimes the defense lawyer will go to the carrier and it's a true evaluation, like, listen, we're liable, or on the other side, and we use this a lot, was like, well, we're maybe liable, but the more that we try to fight it, the higher the verdict's going to be. So let's admit liability, but then just hammer on causation and damages.
Yeah. And
so that's why I call it the yeah but defense. It's not really an admission.
And that is actually what my theme of cases has become, especially when I know that somebody's going to come in and say, hey, look, we take full responsibility for causing this crash. I think, and this is kind of off topic, but the way I've been dealing with that, at least in the trial setting, is to stand up to the jury and say, when a 6th or 7th grader admits I did something wrong, yeah, I did that, But Bobby, you should hear what Bobby did, or Timmy did it too, or whatever the reason is. It's the forced I have to apologize, but I don't really mean it. I don't think there should be consequences for my actions, and that's kind of how I've been addressing it as best I can. Maybe that's just dating a teacher and seeing Bobby and Timmy make up stupid excuses and then be like, they said what? So maybe that's why. But that's how I've been dealing with the trial way.
Yeah, and you really can't do much about it. If the defense lawyer admits liability early in the case, every witness, every corporate witness should, or individual, it doesn't matter, should get the question, okay, here's your answer, you admitted liability. So I assume that now you're perfectly fine with the jury providing or awarding, allowing, whatever phrase you want to use, full damages for the harms and losses. Now at trial, I have two tactics. So I have a great PowerPoint slide that I stole from Mark Lanier. I'm not going to try to act like I'm really smart, but
we've all stolen from Mark Lanier at one point. I venture to say.
And I'm happy to share it with you, but it's a guy talking out of both sides of his mouth, and so I like showing that, saying, yeah, we're liable, but don't pay him any money. And then the second way, my grandfather used to say everything after the but is bullshit. So you got to determine whether the judge will let you curse, but that's a good way to address it as well.
Generally speaking, state court in Metro Atlanta, yeah, maybe. State and superior courts farther away from Atlanta, federal court, absolutely not. That would be my take on that word.
I think you're right.
All right, let's talk about trials real quick before we hit a couple questions. What cases do insurance carriers not want to try based on what you've seen?
I'm going to try to. So I'm not going to say which insurance carriers they were, but there are certain insurance carriers in the Metro Atlanta area who have decided they're not trying any more negligent security cases in the city of Atlanta or in the Metro Atlanta. I mean, the values have just, in their view, gone through the roof.
I wish I could find those carriers. I really wish I could find those carriers. Apparently, I don't have those ones.
Well, they may string you out to the end, but I've heard that. And then obviously trucking, they don't want any part of that. They'll try a products case before they try a trucking case or negligent security. And then if you get med mal, we have a med mal trial starting in 3 weeks in Chicago, and it's a case that should have been paid. But I think that when you take a med mal, you have to assume it's going to go to trial at this point.
Yeah. What can you do? There haven't been trials for the most part, right? For a year and a half, 2 years. General statement, but I think it's pretty accurate. So, you've lost a year and a half, maybe 2 years of trials in all of our careers. Even if, the last trial I tried, I think was January of 2020. I know I tried one November of 19, and that feels like it was yesterday. It's March 2022. I tried one in Athens a couple months ago. I'm trying one a week from Monday, but it's even hard. I'm struggling to give verdicts, because there aren't any, and explain to insurance carriers, hey, I try cases all the time, because it's a hard sell. What are you thinking about that now with COVID and with a delay in trials?
Yeah, that's tough. That is tough. So you have to go off historical data. You don't really have much of a choice. Now, what I've started to do is whereas in the past, I would say, this case is in Gwinnett County or Cobb County or wherever, these are what the verdicts have been the last 10 years, to now kind of broaden it, because there have been some trials across the country, and the verdicts seems to me, been going up. So kind of using that against insurance carriers and saying, listen, we went through the bailouts in 08, 09. Now we've gone through PPP and all this other stuff, and the value of money, juries don't think $1 million is a lot anymore. So that's really the only way I think you can try to convince them. But, one thing I wrote in the note to you, which I think is important, is everybody likes to hang their hat on big verdicts, right? And they should. That's a great thing. But from a defense lawyer perspective, I was always more scared of the guy or girl who tried a lot of cases, even if they lost, than I was of the person who tried a case every 10 years and got a $10 million verdict. Because even if I didn't think that the lawyer was that great of a trial lawyer, which happens a lot, you got to think of it like they may come in and throw a haymaker and hit you. And if they do, it's going to be massive. So the willingness and the track record of trying cases when I was a defense lawyer was more important than the results of the trials.
How do you share with the defense firm that, obviously you want to tell them, hey, I've tried, cases in Metro Atlanta, in wherever, and I've gotten good results. The line I've used before is, we are also not afraid to try risky cases that may not result in a recovery. And our client in this case, whatever case it is, we've apprised them of the risks, and they're prepared to take that risk, and they're willing to risk a zero. Is that a way to convey it that works, you think? To say, hey, I'm okay getting a zero. Now you may not be, but I'm okay getting a zero and I'm willing to do it.
No, I think that's a great way. And insurance companies know. I don't know if they keep a list, so to speak, but once I can tell you that you were on the list. When I was a defense lawyer, the insurance carriers knew that you would try the case, and they knew that you would work up the case. So once you do it enough times, your name gets around, and I don't know, they may have an internal list. They never shared it with me if they do, but they know who tries cases. And then, another aspect of it, which I think that you really touched on that's great, is especially with time limited demands, pay $1 million, pay $50,000, whatever the case may be, within 10 days, the check in hand in 14 days. And then what I've started to write at the end, don't come to me the week before trial and offer me the $50,000, because I'm not taking it. And my client has, told me that we don't have to take it. So don't think I'm going to come back in. You can pay the same amount on the eve of trial.
We've had that problem lately, or I say problem. I think we've started resolving that problem, which is I send offer of judgments and offer of settlements pretty aggressive. And I'll tell everybody in the world, I tell the lawyers, the defense lawyers, if I send you an offer of settlement, I want you to pay it. If I send you an offer of judgment, I don't want you to pay it, because I don't think you can, because no one wants a judgment entered. But what I find is that the defense lawyers and insurance companies backtrack later and say, hey, a year ago, you sent me an offer of judgment for this amount. Will you take that? No. And then they're shocked. So what I've started doing is, when we send the offer from the beginning, is saying, once you deny this, we're adding 40% to the case value. That's already in our math. This is our lowest number. It also helps with mediation, where, I have defense lawyers before I started explicitly saying this up front, that once you don't pay this offer of judgment, I'm going up. I'm going well up, or I'm going way up. I've had defense lawyers be stunned at mediation. What? Well, you've already offered to settle the case for this. Yeah, but then you blew it, and now there's more risk on you, and I have a larger reward at the end of this. So I think that's important, to almost be transparent with why you're making the offer and what your end goal is.
Yeah, no, that's perfect. And what I've started to do recently, and really maybe it's just to needle them, and I want the defense lawyer to have to go back and explain to the carrier why I won't take that anymore. Yeah. So if the deadline's 5 p.m. and they send a denial at 5 p.m., at 6 p.m. I'll send another settlement demand for like double, or whatever the case may be, just so it's on file. And
yeah,
really, it just makes me feel better, I guess.
I do want to mention, for people who aren't trying a lot of cases, a lot of lawyers aren't, and you don't need to. And some days, folks, if that's you, I'm jealous of you not having to try cases, because for a little while there during COVID, it was kind of nice. And you're trying 4 or 5 here in just a few months. So, I know that's exciting, but there are some drawbacks. But if you're sending demands and trying to convince an insurance carrier, and you're not somebody who tries a lot of cases, that's okay too. I think then you need to go as best you can to historical data, pay case metrics, ask your friends, email me, you, whoever, and say, do you know about any verdicts that are similar to my case? That's going to be your friend. Other lawyers are going to be your friend, and relying on those results, which is what I did for the first however many years of my practice when I didn't have the verdicts to back up, right? So it's hard I imagine when you started, you have a partner who's tried a lot of cases, that helps the name. But what do you say to insurance carriers? I tried a lot of cases and I got some defense verdicts.
Yeah. I mean, so I still use it. I say I was an excess defense lawyer for 10 years, and I can't imagine you would ever not sell this case, and believe me, we talk about trial. The threat of trial is actually worse than the trial in my, or better, I guess, to get your case settled. But it's like my partner, Brett, says. He's here in Arizona with me. We're members of the National Association of Settlement Lawyers. It's better for the client. It's better for you. And yeah, we have a lot of, believe me, it's not fun around my office right now, as some of my folks can tell you, trying to get ready for these back to back or whatever.
Well, you try cases or you settle cases to try. Wait, I'm going to do it right. You try cases so you can settle cases. I mean, that's the goal.
Correct.
Right? Yeah. If I can get fair value on settlements, I will never try a case again. I mean, especially the larger the case is, the harder it is to justify. You think the case is worth $5 million, they're offering you 4.75. That's a really tough sell to say to your client, hey, let's risk 4.75 to get an extra 250. I think that's called pot odds in poker. But last thing I want to ask you about trial is, and I'm sorry, we're running long here. I didn't mean to keep you, so tell me to shut up.
Yeah, all good.
I know you're not on Eastern time, so I felt like I had a little bit more.
Yeah, no, we're good. I'm good until 9.
All right, well, I'll get you out of here sooner. You mentioned in when we talked in some notes about dangling a settlement offer right before trial for a distraction. Tell me about that.
Yeah, so we used this tactic when I was a defense lawyer, and they kind of do it with mediation as well. It'll be radio silence. You'll do all the pre-trial work, which is really the hard work of the case, and it's not fun. And then they'll come to you 4 or 5 days before trial and start dangling numbers in your face and in your client's face that they don't really care if they have to pay or not. And really, our tactic a lot of times was to either create a rift between the client and the plaintiff's lawyer, or just to distract the plaintiff's lawyer. It's just human nature that when you think the case may resolve, that you're going to let off the gas, even if you're consciously trying not to, and to keep your foot on the pedal. It's just, I think, in my opinion, it's just human nature. So I'm dealing with it. I'm not going to get into specifics with the case here, and I've dealt with it in the past on the plaintiff's side, and they'll even do it during trial, right? They'll come to you after certain witnesses and say, well, that didn't go very well for you. Here's a number. So the tactic that we've used, and because we're in Alabama and some other places, we were able to try a few cases during the pandemic. And the tactic,
because we're in Alabama, we were able to try cases. Sorry.
Because we had places where COVID apparently didn't exist. We were able to try a few, and what we started to do is actually designate one of our team as like settlement counsel during trial. So like if it's a case that I'm taking most of the witnesses on, Brett they'll come to me and I'll say, talk to Brett. I'm not negotiating with you, talk to Brett. If it's a case where Brett's handling most of it, I'm the settlement counsel, and we talked to the client before about certain numbers. And that way the lead trial lawyer is just not getting distracted, and you can keep going full bore.
One lesson I've learned in addition to that is, if you are offered a settlement without a time limit leading up to trial or even during trial, and you don't want to accept it, don't say no. Leave it open in case something happens. Because the last case I tried, which was in Athens, it was 2 defendants. There was an issue. Only one of them was at fault. One of them was, but only one of them was, and we didn't know. We truly didn't know which one was responsible. The facts don't really matter. But the one I didn't think was responsible, and turned out not to be, had made a settlement offer before trial. And I just didn't respond. And they kept asking me up to the morning of trial, are you going to, I'll get back to you. I'll get back to you. And then once it was confirmed that they weren't responsible, I leaned over in the middle of somebody's cross-examination. I kid you not, I'm crossing a witness. And I said, I accept your settlement offer. And then just kept going. And I did that for a few reasons. I wanted the jury to see the settlement. I wanted to see if, there were some other reasons at play. But in all seriousness, don't deny those settlement offers, because if something does go terribly wrong, or the client has a change of heart or whatever it is, you can still go back and accept that at any time. And it's a it's a real, it's, I don't know, it's a motivator. It's like it breaks your back if you're the defense lawyer and you're like, God, why didn't I put a time limit on that? And if you're a plaintiff's lawyer, on the reverse, make sure you do put a time limit on your settlements. So that way, if the case is going really well for you, you don't get them accepting an offer that you wouldn't have made at the time. All right.
I never thought of that. That's great.
Oh, yeah. Judge wasn't particularly happy with me, but it was probably the most fun I've had in a trial in a very long time. Let me ask some of the questions that you were asked specifically. If you return to the defense side, what would be the biggest change in how you would approach cases? And that's funny to me, because when I started my own firm or left the defense world, I always thought the worst thing that could happen is I'll have to just go back and do defense work, and at least I'll be able to say to people, well, you know, I did plaintiff's work and that's really helped me, and I never got to the how it's helped me. So looking based on what you know now, what would you do differently?
This is going to be a weird answer, and nothing. I mean, I was lucky enough to
yeah. I mean, have you seen the Conor McGregor? I was at the UFC fight where he broke his ankle. I think the guy's the most entertaining in the world. But he beats somebody. I think it was like Jose Aldo or something. Somebody he wasn't supposed to beat. And he grabs the mic from Joe Rogan and says, "I'd like to apologize to absolutely effing nobody." I feel like that's what you just did. You're like, "I'd like to apologize to nobody." And I've done it, but explain why.
Yeah, no, and it's going to be a good day if I just got compared to Conor McGregor. You know, because I was lucky, and you know, I saw Chloe Delaires on here, and I worked with her very briefly, and really looked up to her when I started at Weinberg Wheeler. I was very lucky to work under guys and girls who I think were true trial lawyers, and we were kind of taught always to see it from the plaintiff's perspective, to a certain extent. And so I really don't think I would change much. I think that I was handling cases the way they should be handled. The cases that should be settled were getting settled. And then, you know, one thing, you know, tactically speaking, I would say, is I would prep my witnesses better, knowing that everything is trial by video now. I kind of did your old school discovery, deposition, prep sessions, which honestly, you know, maybe we're a little half-hearted now if I look back on it. So I would probably spend more time with witnesses, preparing them for quote unquote trial testimony during depositions. And then I would do more witness work. I mean, on the defense, especially the cases that we handled at Weinberg Wheeler, a lot of times we were getting them so late, there's no time to do witness work. So if I were a defense lawyer, I would have spent way more time actually going out and finding the independent witnesses.
I know the answer to this question that Michael Arndt asked. He asked maybe a bit abstract, but what's your sense of how likely cases are actually tried with sufficient facts? And do you think it's more or less likely in big or catastrophic cases? I imagine the answer, at least whether larger cases are being tried more often, is it really is lawyer driven and it's really facts driven. That's the lawyer answer I'll give for the day, but you have a thought on that?
I want to make sure. So what was the question exactly? I want to make sure I understand it. Okay, I see here. All right.
You can see too. Okay.
Yeah, sense of how likely or try with sufficient facts. Okay. Yeah, I think if the case has been developed and worked and all the cards are on the table, most of the time they're not. Obviously, most of the time they're not going to get tried. I think it's you know, I actually think it's more likely in bigger cases. That's kind of, I don't know, but I think it's more likely in bigger cases, especially if there's a divide on the values.
Yeah, because of the I mean, my answer would be because of the margins. If you disagree on 25% of a $2 million case, you're talking, you know, hundreds. What is that now? $500,000. If you disagree on 25% of a $10,000 case, a $25,000 case, who's trying to case? You know, unless you have to, you're not trying to case over that margin of disagreement because it doesn't make sense from a cost perspective. And then, when you were the excess carrier, were you typically seeing the primary layer tendering and then you'd handle the case?
Yes, but it's very late in the process, and it's getting worse and worse and worse. It's one of the most frustrating things that I've run into the last 3 years on this side is carriers now are waiting until the last second, and you're not really getting to the real money until too late in the case. But yeah, most of the time when I had it in defense, it was tendered by the primary, or sometimes you run into the excess just takes it over. They say, yeah, the primary won't tender it, but this is fucked up, and we're just going to jump in.
Yeah, just real quick, give us the 15-second what tendering is in case there's somebody out here who hasn't run into this or maybe has and doesn't know what it's called.
Yeah, so it's where the primary layer goes to the excess layer and says, this is our money's out of play. You're the one that's in the bullseye here. You pay defense costs. Your indemnity's in play.
Yeah, and is there ever a disagreement on that you've seen?
Oh yeah, insured excess carriers will say no, we're not accepting your tender, and that's a bad scenario too.
Yeah, the best scenario is when they come in and say we're taking over the case because then at least they value it, and that's when you start sending that hammer letter or getting them to send the hammer letter. Hey, hammer down to them, hammer down to them, hammer down to them if you're willing to take that money. But in that situation, you shouldn't be because the excess carrier thinks they're in play. All right, so dude, this was awesome. I mean, seriously, you're wearing your green, by the way, for Conor McGregor. I meant to tell you that. So don't get drunk and beat up the bus, at least until after your case is over. But yeah, no, this was awesome. I don't feel as stupid as I thought I would feel, but I also learned a ton of stuff, and I think that that this is hopefully going to help a lot of people. So I really, really appreciate you doing this. How can people reach you? What's the best way other than going on georgiabar.org and sending you an email? That's the best way to reach out if somebody wants to talk to you?
Yeah, no, email's good. Holcomb@turnbullfirm.com. I'll put that in the little chat here. Our website is turnbull.lawfirm.com. Twitter, Alan Holcomb @Alan Holcomb, and
me and our mutual friend who who I'm talking about goes by 3 letters. We were talking about your Twitter the other day and your Instagram. I thought I was the only one who followed you, but yeah, I like the posts. I can't keep up with all of them. You're outposting me on my daily LinkedIn tips of the day. But it's it's like stuff that I can tell. It's stuff that just crosses your mind that you want to say. I can almost tell what's going on like in your life based on certain posts.
Yeah, it's usually when I've had a couple of drinks on a plane and I'm really pissed at somebody. That's like my venting, the way I vent. Yeah, but I know who you're talking about, and they're calling me a fraud. So
I see the comments too. All right, so I'll get you out of here. Good luck at your trial, at all of them. And I kid you not, I think Alan Holcomb is I'm saying this about you in the third person just because I'm telling everybody else. I think Alan Holcomb is one of the most thoughtful and most thorough and most strategic in a very positive way lawyers that I know. He is on my very short list. We shared a case. I probably should have said this earlier. We shared a case where he got more money than I ever thought would happen, and it helped me as well. I had the companion case, but I think Alan's a great resource for you. He's always wanted to go out of his way. So if you need help, reach out to me, reach out to him. I say that on his behalf. But Alan, I appreciate you joining me. I'm gonna kick you out like I said I would, but good luck on your case, and hopefully you have a verdict that we can all point to and say, look, juries know the value of money post-COVID.
Awesome. Thanks for having me, man. Appreciate it.
All right, to everybody left, I appreciate you joining me. I hope that this was a webinar that you enjoyed. Frankly, it's one of the most fun ones that I've done. It reminds me of the one I had with Austin Bersinger way back where we talked about bad faith and excess verdicts. It's fun for me because it was 2 of my friends that I got to talk to. I didn't have to do the heavy lifting. I have to ask questions, but also I learned a ton, and I hope you did too. And I'll leave you with this thought. I try to leave all these webinars with one quick thought. I got asked the other day why I do these and why I would have another lawyer on my webinar, especially someone who, I've had cases where clients have looked at, have considered hiring me and have considered hiring Alan and his firm. I've had other people on the webinar where, they are competitors. I'll leave you with my thought of, we are all in this together, on the work side, on the world side, with what's going on in Ukraine and Russia. I don't think we can ignore that. But use everyone as a resource. People who do the same thing that you do in work are not your enemies. People who do different things are not your enemies. And the guy walking down the street that you see that looks like he's in a really bad mood or having a bad day or is a jerk to you, you don't know what's going on in his mind, in his life. He may have a halfway decent reason. So give everybody benefit of the doubt as you go. Reach out to the resources that you have, whether it's work or life. I wish you all the best. Let's all hang in there. And I am here for you whenever you need it. So is my dog, who's been hanging out here all day. Bunker. What up, man? You don't look good on camera right now. So anyway, we are here to help you. Let me know what I can do. But thanks for joining me, and have a really, really good rest of the month. I'll see you all the first Thursday of April, with an asterisk on that. It may change to the second week. I think that is spring break, but we got a couple weeks to figure it out. Thanks for joining. Look for my emails, and I'll talk to y'all soon. Adios, everybody.